registered a set of photos with LSC, and several friends who worked there, and one of them was a librarian, and she couldn't find my stuff. It was like, well, where is it?
Well, you can imagine they have massive warehouses full of stuff, and they digitize some of it for searching, but they really, going back, I mean, copyright protection is actually in the Constitution, and going back to the old days, they literally had copies of everything on file. It was the public library, the public repository of all of this great invention and art. And so they have to maintain these physical copies. They lose a lot of things these days, or they get damaged in the mail. They have extra precautions because they're so located in DC, close to the Capitol. When the whole anthrax mailing problem happened a few years ago, they had to add extra provisions for routing the mail and opening the mail, and it's made it, that's part of the reason for the delay. I can't tell you what happens to it, other than that it's not uncommon to get a notice a year after you file it that says, we can't find your submission, please send us another copy. So important, the key tip is make a copy of when you file them and when you submit them, so that when they ask for another copy, it's easy.
You know the final scene in Raiders of the Lost Ark?
Yeah.
That's where your photos are.
Yeah.
Exactly.
Eric, I have a question. When you file online, do they give a confirmation back at all?
Yeah, you do get a serial confirmation number,
Okay,
and it is a good system, and it is all sort of bar-coded.
Yeah.
They have, as you fill out the PDF, it actually generates like a unique tag on your PDF that you file with them.
Okay, good. So at least if you have that too, it's at least...
It helps. Again, you call them, and it may take them a few weeks to track down an answer to what the status is.
Okay.
But they're catching up to the electronic age, and hopefully this backlog is part of that. It's always well, do we catch up or do we move ahead, and how do you deal with all of that at the same time? Great questions. So, trademarks are another significant type of intellectual property, and trademarks are brand names, logos, slogans, basically what you use to promote your business or your art. So for example, you see in the upper right-hand corner there, I've got a logo for my law firm. That is one of our trademarks. We put that on our letterhead, on our envelopes, on our website. It's not as well known yet as like the McDonald's logo or the Google logo, but we're working on it. But many businesses, big, small, have logos that they use to promote their materials. And it could be a website name, it could be a blog name, that maybe you blog to promote your artwork. Those names and those designs can all be trademarks. And again, the important thing is to identify them. First, be aware that you have them. Use them correctly so that you use a symbol if you filed for it or registered to tell other people that this is your trademark. If you're using it in text, use it in italics or bold to set it apart from the other text so people understand this is something that's different, that is important to us, this brand name. And ideally registered. It is a little bit more complex and more expensive to get a trademark registration. The government filing fee is about $300. Similarly, on average, takes about a year to get a registration. Really, the more important for a trademark is when you select a trademark, when you start using a trademark, don't select something that's very common already or very bland or generic. You're not going to be able to protect yourself or to make that distinctive.
Yeah.
Like Apple?
Well, see, every word is common to some extent, but Apple has nothing to do with computers. So for computers, it's completely unique and has nothing to do with it. If you were trying to open a vegetable stand and you called it, Apples on Broad Street, then it would be a really bad name because it's not very distinctive.
So, because of that, would you have to be very stupid to make a mistake such as getting sued by Apple Records if they still exist? Just simply because of that?
Well, I don't No,
Simply
that's
because it's a totally different business, but
right.
it's exactly the same name. But we're talking about logos now. But the
No, but it applies to names even more so. Names are more important than logos generally, because names are how people remember you, talk about you, find you, search for you on the internet. So when Apple first started, it was just hardware, computers. Nobody, I doubt that even Steve Jobs, envisioned that it would be the top music retailer in the country eventually. And so they can coexist for very different services. Records and computers could coexist. Delta faucets and Delta Airlines coexist. Nobody walks into Home Depot and sees a Delta display of sinks and says, really, the airport people now make sinks? They're two totally unconnected fields of business. As Apple grew, became more online, developed the music, that's where it became a problem. Of course, at the same time, Apple Records grew and became more, all music grew and became more computer and technology. So they eventually grew to where they are arguably overlapping, and they've had this ongoing dispute. They've actually had several settlement agreements and threatens to sue each other over years. So that is an excellent question.
Yeah, these things are same name, different product come up a lot because it happens a lot. And it's usually just ignored because nobody, again, faucets and airlines are different. But in the early 70s, NBC came up with an N logo, and there happened to be a public broadcasting station, Nebraska, which had the same logo, exactly the same logo. The problem here was they're both dealing with television.
Right.
And that was the problem. NBC gave Nebraska $50,000 in cash, $1 million in equipment, and said, kill your logo. And that's how that was.
Great story. Yeah, great story. Right. So it does matter when they are competing, and it also matters how identical they are. If they're very identical,
They were
right. It wasn't right. Then it was unlikely that it was even independently created. But who knows? Two great things. So one is the NBC logo is personally one of my favorite logos.
Which one?
The peacock logo,
Yeah.
the current
second.
logo.
But yeah, okay.
But I know the old logo that you're talking about from the 70s. I didn't know the story about them having to buy the rights to it. But it's that peacock is iconic, and now they'll just have that fan of colors in the bottom of the screen, and that identifies NBC without even having to tell you that it's the letters NBC. That's how strong a brand or a logo can become.
Right, the CBS doesn't use CBS.
Right.
It's just an I. And by the way, that's the second actually that's the third peacock in an evolution. There were 20 feathers, then there were a dozen, and now there's 6.
Okay.
Chermayeff and Geismer did the most recent one.
Yeah, you'll see many logos evolve over time to keep up with the times, and that story also brings. So I was saying, the more distinctive a name you can come up with from the start, the better odds there are that it's unique and that you can protect it. And if you look at many of the most successful companies today, Google, Amazon, eBay, Yahoo, they all have words that mean very little or mean nothing compared to what they do. So they're very strong trademarks, and it allows them to then say, our trademark is so strong and so unique, a Google hamburger stand might be different enough in a normal trademark analysis to say, hamburgers and internet searching, people aren't thinking they're coming from the same source, but Google is so famous and so well known and now has its fingers in so many different things, Google could probably shut down the hamburger stand. Just like McDonald's can shut down almost anybody from using anything for food, or McDonald's for almost any other service, because they become such strong, famous trademarks over time. So trademarks, again, it's identifying, it's coming up with something that's unique and creative, doing a search from the start to make sure that it's unique and creative, and you can search yourself on the government's website. It's more advisable to pay for a professional search and really know that this name is trouble-free. Then it's possible to go ahead and register it. It's not required, but it gives you extra protection and really creates a separate asset for that name or that logo, and it allows you to use the R with a circle, the registered trademark symbol, and then notifying others that this is your trademark. Again, putting it in bold or italics in text or in quotes, something to differentiate it. If you have registered it using the R with a circle, or even stating at the bottom of your website or the bottom of your promotional materials, XYZ is a trademark of your company or your business name. That at a minimum notifies people that this is something that's important to you. Yes, sir.
See, what Google has done is what Kleenex and Band-Aid and Xerox have done. They become real words to a younger generation. They're not actual products. Everybody thinks if you buy a Curad, you've got a Band-Aid, but you don't. You have a bandage. Right. And when you've jumped into becoming a word we use as a dictionary word, that's the ultimate.
Well, then you risk becoming generic, and those companies invest millions, if not tens of millions of dollars in fighting that now. You'll see ads. You'll see ads for Kleenex, and now even on the boxes, it'll say Kleenex brand tissue. They want you to stop calling the whole category a Kleenex, and call it a Kleenex tissue. Same thing as Xerox copier, doing a Google search, not Googling somebody. But to some extent, that's avoided. Aspirin used to be a registered trademark. Escalator used to be a registered trademark. Frisbee and hula hoop are registered trademarks today, believe it or not. I think they're being attacked. But that's a whole separate issue, the genericizing of well-known trademarks. So the last type.
I just want to ask you about, coming from the high-tech industry, it was very important that whenever we allow partners to use logos, or anybody use your logo, or you use your logo, that you have to be very consistent. That's what was beaten into us. You have to be very consistent with it, because if you allow people to start using it, then you have lost the precedence that it's yours. And tell me if I'm right about this. And so going to court, so if you have a logo that's very unique to you and your art, or the company that you have, your art company, that if you allow people to use it and abuse it, you've kind of lost some rights to it. Am I correct on that?
Yeah, if it's used improperly, that can come back to harm you, and that also goes to the contracts, which we'll discuss later, about controlling the use. Let's say you authorize them to use it on only certain types of products, you then want to make sure that they're not using it on other types of products, and that you're missing out on revenue from that, or it's a product that you don't endorse, so that it doesn't make sense for your logo to be connected to. So